There is a specific kind of absence that is different from ordinary absence. Ordinary absence is when someone is not in a room, not in the house, not in the city. It is the absence of a person who is somewhere, living their life, and whose non-presence in yours is a logistical fact rather than a wound. The other kind of absence, the kind I grew up with, is the absence of a person who chose not to be there, who had the option and did not take it, who looked at what they had made and decided, deliberately or through the particular cowardice of people who cannot face their own decisions, that they were not going to be part of it. That kind of absence has a shape. It takes up space. It sits at the dinner table, and in the bleachers at school events, and in the silence after other kids' dads pick them up after practice. It is present in its own way, constantly, in all the places where it should not be. I have not called him Dad in 30 years, and I do not intend to start now, so I will call him Richard throughout this story, because that is what he is to me. A person named Richard who is biologically related to me and who made a series of choices that I am going to tell you about in detail. Richard left on a Wednesday in October when I was 9 years old. I know it was a Wednesday because I had a spelling test that morning and my mother had drilled me on the words the night before while Richard sat in the living room watching television. And I remember the specific normalcy of that Tuesday evening, the kitchen table, the flashcards, my mother's voice saying the words and waiting for me to spell them as the last ordinary evening before everything changed. Wednesday morning, I came downstairs, and my mother was at the kitchen table with her coffee, and her face had something on it that I did not have a name for at 9 years old, but that I would later come to recognize as the particular expression of a person who has been crying and has stopped and is now holding themselves very carefully together. Richard was not there. "Where's Dad?" I asked. My mother wrapped her hands around her coffee cup. "He had to go somewhere," she said. I ate my cereal and went to school and took my spelling test. I got a 94. I missed necessary. I put 1 C and 1 S instead of 1 C and 2 S's, a mistake I have never made since, because that word is permanently associated in my memory with that morning, with the last ordinary morning, and certain memories carve themselves into you with an accuracy that no amount of time fully erases. When I came home that afternoon, my mother sat me down at the kitchen table, the same table from the night before, and told me that Richard had moved out, that he and my mother were going to be living separately for a while, that this did not mean he didn't love me, that sometimes adults had to make hard decisions. I said, "Is he coming back?" My mother paused for just a moment too long before she said, "I don't know, sweetheart. He did not come back. Not that week, not that month, not that year. He sent a birthday card in December. I turned 10 in December, with a $20 bill inside and his signature. Just his name. No message beyond it. My mother put the 20 in my college savings account, which at that point contained approximately $240, and she put the card in a drawer, and she did not say anything about it except to note that it had arrived. The child support order was established 4 months after he left, through the county family court. My mother had to hire an attorney she couldn't really afford. She paid him partly in cash and partly in work. She was an administrative assistant, and she did some overflow typing and filing for his office in exchange for a reduced rate. The order established that Richard was required to pay $380 per month in child support, based on his income at the time, which was from a job he had in warehouse management in a suburb of Cleveland. He paid exactly 1 month. After that, nothing. I am going to let that sentence stand on its own for a moment, because I think it deserves to stand on its own. He paid exactly 1 month. After that, nothing. Not because he couldn't. The enforcement records, which my mother kept meticulously in a manila folder that she never showed me, but that I found after I was grown, filed in a filing cabinet in her closet, with a label written in her careful handwriting that said simply, "Richard," document that he was employed continuously for most of the years following the order. He had income. He made choices about what to do with it. And the choice he made, consistently, for 29 years, was not to spend it on the child he had left behind. She worked the way that women in her situation work, which is to say, constantly, creatively, without complaint in front of their children, and probably with a great deal of private despair that I was too young to see clearly, and that she was too proud to show me. She was an administrative assistant during the day. And, for most of my middle school years, a waitress on weekend evenings at a family restaurant that smelled of fryer oil and industrial cleaner, and where she worked until closing and came home with her feet hurting and her tip money counted and sorted into the small categories she maintained: rent, groceries, utilities, emergency. There was never a category for anything extra. That is what I want you to understand about the material reality of my childhood. Not that we were in crisis, not that we went hungry, but that the margin was so thin that there was no cushion, no buffer, no room for anything to go wrong without immediate consequence. A car repair was a crisis. A medical bill was a month of juggling. The particular anxiety of living that close to the edge of things, the constant low-grade vigilance of it, is something I carried into adulthood in ways I am still, at 38, working to understand and unwind. Richard, meanwhile, was living his life. I know this because children in situations like mine always find out, eventually, in fragments and overheard conversations, and the occasional piece of information that slips through. He was in Cleveland. He had a new girlfriend within a year of leaving. They married when I was 12. They had 2 children, a girl and a boy, who are technically my half-siblings, and who I have never met, and who, as far as I know, grew up in a house in a suburb of Cleveland, with a father who apparently had no difficulty being present for those particular children. I have spent a long time trying to understand that, the calculus of it. The man who could not stay for me and my mother, who could not be bothered to send $380 a month for the child he had made, was apparently capable of being a father, just not to me. What does that say about him? What does it say about me? I asked those questions a lot between the ages of 9 and about 30. I stopped asking them around 30, not because they were answered, but because I finally accepted that some questions do not have answers that will help you, and that continuing to pursue them is a way of staying in the wound, rather than building beyond it. But I am getting ahead of myself. Let me stay in the chronology. I grew up. That sounds simple, but I want you to understand that it was the most deliberate thing I have ever done. Growing up, on purpose, with intention, without the resources or the blueprint that most people take for granted. I was a good student. Not because I was particularly naturally gifted. I was smart enough, but not the kind of effortlessly brilliant that some people are. But because I understood early that school was the most reliable ladder available to me, the structure most directly connected to the future I wanted, and so I treated it with a seriousness that occasionally alienated my peers, and that my mother recognized and encouraged without being able to fully explain its source. She knew its source. I knew its source. We just didn't talk about it directly. We talked around it, the way families who love each other talk around the things that hurt too much to say plainly. I played sports in middle school, soccer briefly, then basketball, partly because I liked it, and partly because I think I was chasing something in the structure of a team, the presence of coaches who paid attention to whether you showed up and how hard you worked, men who evaluated you on merit and told you clearly when you did something well. I was not conscious of this at the time. I understand it now. In high school, I was the editor of the school newspaper, which I mention not as a credential, but because it was formative in the specific way that things are formative when they give you the first real sense of your own competence. I was good at it. I was good at the editing and the writing, but more than that, I was good at the management of it, the coordination of deadlines and people, and the particular chaos of putting a publication together on a schedule. I liked having a problem and solving it. I liked the moment when something that had been scattered and unresolved became organized and finished. That liking, I would later understand, was the seed of what I became professionally. I applied to 7 colleges. I was accepted at 4. I chose a mid-sized state university in Ohio on the basis of the financial aid package, which was the most generous of the 4 acceptances and made the difference between possible and impossible. My mother drove me to orientation in August, and we unloaded boxes from her car in the parking lot of the dormitory, and she hugged me for a long time in the heat of the afternoon, and she did not cry until she was in the car and pulling away, at which point she cried quite a lot. And she told me this years later, as if it were a slightly embarrassing confession, rather than one of the most understandable things I have ever heard. I studied business, and then, in my junior year, found my way to law, not as a plan initially, but as an interest that deepened through a pre-law elective and then through a conversation with an advisor who looked at my transcript and said, bluntly and without preamble, "Have you considered law school?" I had not. Not seriously. Law school meant 3 more years and more debt, and the law school admissions process, which was its own universe of complication. My advisor said, "You're organized, you're analytical, and you clearly enjoy figuring out how systems work. Those are the 3 things that make people good lawyers." I took the LSAT the following spring. I scored well enough that my options were real and worth taking seriously. And I spent my senior year applying to law schools with the same methodical seriousness I had applied to everything else. And I was accepted to a program I was proud of, and that I attended on a combination of scholarship and loans that I would be paying off for the better part of a decade. I want to tell you about law school as briefly as I can, while still honoring what it actually was, which was 3 of the hardest years of my life, in an entirely different way than the hard years that came before. The difficulty of growing up without resources is the difficulty of scarcity, of not having enough. The difficulty of law school was the difficulty of intellectual demand, of being in a room full of extraordinarily capable people, and having to prove continuously that you belonged there. Those are different difficulties, and they require different things from you. I belonged there. It took me about a year to fully believe that, but I belonged there. I graduated and passed the bar on my first attempt and took a position at a mid-sized firm in Columbus doing family law, which I had not planned as my specialty, but which I discovered during my 3rd-year clinic work was the area where I could do the most concrete good for the people who needed it most. Family law at its best is the work of helping people in crisis navigate systems that were designed by and for people who are not in crisis. It requires patience, precision, and the ability to stay steady when everything around you is not. I was good at it. I am still good at it. I spent 6 years at the firm before going out on my own, starting a small family law practice with 2 colleagues who had been at the same firm and who shared my orientation toward client-centered work over billable hour maximizing work. We are not a large practice. We are a good one, and I am proud of it, and I want to be clear about that, because what I am about to tell you about my professional life is not the central point of this story. The central point of this story is something else entirely. But I think the context matters, because it changes what happens when a Facebook message arrives. The Facebook message. I want to describe the circumstances in which I received it as precisely as I can, because the circumstances feel important to me. It was a Sunday evening in March. I was at my kitchen table with a glass of wine and a case file I was reviewing. I often review cases on Sunday evenings, not because I am a workaholic, but because Sunday evenings are quiet, and the quiet helps me think. My cat, a large and opinionated orange tabby named Council, was sitting on the far edge of the table, pretending not to be interested in my wine. My phone lit up with a Facebook notification. I do not use Facebook much. I have an account primarily because some clients communicate through it, and because my mother is an enthusiastic Facebook user, and it lets me see her posts without her having to explain the internet to me. And so a Facebook notification was unusual enough to make me pick up the phone. The notification said, "Richard, last name, sent you a message." I stared at the notification for a moment. Then I opened it. The message was long, longer than I expected, more than 300 words, which suggested that either he had written it carefully or that he had started it and kept going in the way people do when they have been rehearsing something for a long time and then finally say it all at once. He introduced himself, which struck me as both absurd and somehow necessary given the circumstances. He said he was my father. He said he thought about me often. He said the years had passed in ways he hadn't expected, and he found himself, at 67 years old, thinking about the choices he had made and the people he had left behind. He said he wanted to make things right. He said he was sorry for the past. He said he hoped I was well, and that I had built a good life for myself, and that he would understand if I didn't want to respond, but that he felt he had to try. He did not mention the child support. I read the message twice. Then I set my phone face down on the table and looked at the case file I had been reviewing for a few minutes without reading it. Then I picked up my phone and forwarded the Facebook message to my office email address. And then I sent a text to my colleague and friend Marcus, who is also an attorney and who has known my history for most of the time I've known him. And the text said, "Richard just messaged me on Facebook." Marcus replied within 2 minutes, "What are you going to do?" I replied, "I'm going to let him wait a few days and then I'm going to call Janet." Janet is my colleague who handles the more complex financial litigation aspects of our family law practice. She is meticulous, fearless, and has a particular specialty in the enforcement of long overdue child support orders that has made her something of a legend in the family court circles of our county. I called Janet on Tuesday. She came to my office, closed the door, and listened while I told her the full story. Richard's departure, the child support order, the 29 years of non-payment, the Facebook message. She took notes on a legal pad in the neat, angular handwriting that I have always associated with her. When I finished, she looked at her notes for a moment. Then she said, 29 years of unpaid support at $380 a month is approximately $132,000 in principal. With interest, depending on how the state computes it, we're looking at somewhere in the range of $200,000 or more. I said, "That's what I calculated." She said, "Ohio doesn't have a statute of limitations on child support enforcement. The order is still active and enforceable." I said, "I know." She said, "Do you want to pursue this?" I thought about it. Not for long. I had been thinking about it since Sunday evening, and I had arrived at an answer. But I took the moment to let the answer be final. "Yes," I said. Janet said, "Okay, don't respond to the Facebook message yet. Let me do some preliminary research, and we'll talk again Thursday." Thursday. Janet came back to my office on Thursday with a more complete picture. She had located Richard through public records. He was living in a suburb of Cincinnati now, apparently having moved there some years ago. He was retired. He owned his home, which had equity. He had Social Security income and, it appeared, some retirement savings. He had assets. He had also apparently been trying to locate me for some time before the Facebook message. There was a record of a letter sent to my mother's address 2 years earlier that neither of us had known about, which told us that the message had not been the impulse of a single Sunday evening, but the culmination of a longer effort. "He's been working up to this," Janet said. "Why now?" I said. "Health, probably," she said. "People in their late 60s who have unfinished business tend to develop urgency about it. Also, there's a term in estate planning for what he may be trying to do, getting ahead of potential claims. If he contacts you voluntarily, demonstrates remorse, establishes a relationship, it changes the nature of any future legal action. He's trying to manage his exposure," I said. "I think he's also genuinely remorseful," Janet said, in her careful, fair-minded way. "The two things aren't mutually exclusive." "No," I said. "They're not." We talked through the strategy. The child support enforcement process in Ohio involves filing a motion with the family court that issued the original order, documenting the non-payment, and requesting judgment for the accumulated amount plus interest. Because Richard had assets, property, retirement savings, there were real mechanisms for collection. This was not a case of pursuing money from someone who had nothing. This was a case of pursuing money from someone who had made choices for 29 years, and those choices had consequences. I also made a decision that I want to tell you about, because I think it's the most important decision I made in this entire process. I decided to respond to the Facebook message. Not immediately. I waited until Janet had filed the initial paperwork, which took about 3 weeks. But I wanted to respond, and I want to tell you why, because it would have been easy not to. It would have been easy to simply let the legal process proceed without any personal communication, to let my attorney be the only channel, to decline the reconnection entirely and just pursue the enforcement. I didn't do that for 2 reasons. The first reason is professional. I am a family law attorney. I have sat across from enough people in enough variations of this situation to understand that the legal process and the human process are different things, and that people who only pursue one tend to end up with an incomplete resolution of the other. A court judgment can quantify what Richard owed and compel him to pay it. It cannot resolve what I actually felt about 30 years of absence. Those are 2 different categories of need, and they require different actions. The second reason is personal and harder to articulate. I am my mother's daughter. My mother, who worked 2 jobs and maintained a manila folder, and never once in all the years I was growing up spoke to me about Richard with bitterness. She spoke factually when she had to speak about him at all, and she never positioned herself as a victim, and she never positioned me as one. And I absorbed that from her, the way you absorb the things that are modeled for you before you have the language to understand what you're learning. I did not want to respond to this situation from bitterness. I did not want the response to be only legal, only transactional. I wanted to respond as a full person, which meant engaging with the human dimension of it, even while the legal dimension was being addressed. So I responded. The message I sent was short. I said, I received your message. I want you to know that I am doing well and that I have built a good life. I also want you to know that my attorney has been in contact with the county family court regarding the child support order that was established in 1994. You will be receiving correspondence from the court. I am open to speaking with you directly at some point, but I think it's important that the legal matter be addressed first and clearly. I wish you well. I sent it on a Tuesday morning, and then I closed Facebook and went back to work. He replied within an hour. The reply was shorter than the original message. It said, I understand. I am sorry. I should have done better. I will cooperate fully with whatever the court requires. I showed the reply to Janet. She said, that's actually a more cooperative response than we often get. I said, he knows he doesn't have a position. She said, he knows. The legal process. I want to walk you through what happened over the following 11 months. Not to turn this into a dry procedural account, but because I think the specifics matter. Because when people hear, I let my attorney handle it, they sometimes imagine a clean, swift process, and family court enforcement is rarely clean or swift. We filed the motion in April. The family court, the same county court that had issued the original order 29 years earlier, accepted the filing and set an initial hearing date for June. Richard did not have an attorney at first. I think he had been hoping, based on his message and my response, that this could be handled informally, outside of court, as a personal reconciliation with some financial component that he could control. When the official court paperwork arrived, he understood that was not what was happening. He retained an attorney in May. His attorney's initial response was to dispute the calculation, not the existence of the order, that was unambiguous, but the methodology of the interest calculation, and also to raise the argument that Richard had, at various points, allegedly made informal payments to my mother that had not been formally recorded as satisfaction of the order. This argument required a response, and the response required documentation. My mother. I have to tell you about calling my mother, because it was one of the harder conversations in this entire process, and I want to honor it. I called her on a Saturday morning in May. She lives in the same city she always has, in a small house she bought 12 years ago. The first property she ever owned, purchased with the savings of a lifetime of careful budgeting. She is 61 now. She is healthier and more settled than she was when I was growing up, in the way that people become more themselves when the acute pressure of survival eases even slightly. I told her what was happening. All of it. The Facebook message, the decision to pursue enforcement, the filing, Richard's attorney's response, and the informal payment claim. She was quiet for a moment. Then she said, he never made any informal payments. I said, I know, Mom. She said, not one, not in 29 years. I said, I know. He sent a birthday card with $20 when you turned 10, she said. I still have the card. It's in the drawer in the filing cabinet. I said, that drawer with the folder labeled Richard? A pause. Then, you found that. Years ago, I said. I never said anything. She was quiet for a moment. Then she said, I kept everything. Every notice I ever sent to the enforcement office, every letter I received, every record of communication that went nowhere. I didn't know why I was keeping it. I suppose I thought someone might need it someday. I said, someone needs it. She mailed me the folder the following week. It arrived in a padded envelope, and I opened it at my kitchen table, and I sat with it for a long time. 29 years of documentation, notices filed and ignored, enforcement requests that went into a bureaucratic void, letters sent to addresses that were no longer current, my mother's careful handwriting on each document, noting the date it was sent or received, the action taken or not taken. It was the most thorough record of a person being failed by a system that I have ever seen, and I have seen many. Janet used the folder to build a response to Richard's informal payment claim that was, in her words, airtight. We submitted documentation of every official communication related to the order. We submitted the birthday card, the $20 card, as Exhibit A, with a note that it was the only financial gesture Richard had made toward his child in 29 years. Richard's attorney withdrew the informal payment argument after reviewing our submission. The judge, a woman in her late 50s who had clearly seen every variation of this situation many times and who had the particular patience of someone who is done being surprised, reviewed the record and asked Richard's attorney whether there was any dispute about the underlying facts of non-payment. There was not. She set a second hearing for August to determine the total amount owed and the method of satisfaction. The August hearing. I want to tell you about the August hearing in some detail, because it was the moment in this story that I had been in some unacknowledged way building toward for 29 years. Richard was present. I had not seen him since I was 9 years old. I want to describe that moment, walking into a courtroom and seeing across the room a man who is biologically your father and who is also essentially a stranger, because I had imagined it many times and the reality was both what I expected and entirely different from what I expected. He was old. This seems obvious. He is 67. But I had carried a version of him in my head for 3 decades that was the version who had left, the version who was a man in his late 30s, and the person sitting at the table across the courtroom was elderly in ways that face and body cannot hide. He was heavier than I imagined. He was gray. He was wearing a suit that fit him well, and he was sitting very straight. And when I walked in, he looked at me. I looked back. I want to tell you what I felt in that moment, and I want to be honest about the fact that it was not what I had expected. I had expected anger, the clean, righteous kind of anger that makes things simple. I had expected a flood of feeling, the accumulated 30 years of absence arriving all at once in a courtroom. What I felt was, more than anything, tired. Not emotionally drained. I was present, I was sharp, I was fine. But somewhere behind my eyes and in my chest, there was a deep tiredness. The tiredness of having carried something heavy for a very long time and being very close to putting it down. I sat with Janet at our table. I did not look at Richard again during the hearing. Janet presented our calculation, 29 years of unpaid support at $380 a month, $132,040 in principal, plus statutory interest calculated according to Ohio law, bringing the total to $211,320. Richard's attorney offered a counter-calculation that was slightly lower, different methodology on the interest. The judge had clearly reviewed both calculations and had her own. She asked several precise questions of both attorneys. She was efficient and thorough, and she did not perform any emotion about the situation, which I found deeply reassuring. After about 40 minutes of argument on the calculation methodology, the judge ruled. Total judgment, $206,800. She then addressed the method of satisfaction. Richard's attorney had submitted a proposal, a structured payment plan over 5 years, drawn from Richard's retirement savings. Janet had submitted a counter-proposal, a combination of a lien on Richard's property and a direct draw from a portion of his retirement account. The judge considered both proposals. She asked Richard's attorney whether Richard was prepared to cooperate with a lien on his primary residence. Richard's attorney said yes. The judge issued an order establishing the lien and setting a payment schedule. She then said, and I want to quote this as closely as I can, because I have replayed it many times since. She said, "I want to note for the record that the order that was issued in 1994 was clear and legally binding, and that the obligor's failure to comply with it for nearly 3 decades represents one of the longest records of noncompliance I have seen in this court. The amount now owed reflects not just the principal obligation, but the compounding consequences of 30 years of choices. I hope this resolution brings some measure of justice to the parties involved." She looked up from the bench. "We're adjourned." After the hearing. I want to tell you what happened after the gavel came down, because the procedural part of this story, the filing and the hearings and the judgment, is not where the story actually ends. Janet and I walked out of the courtroom into the hallway. She was gathering her papers. I was standing still, doing the particular internal accounting that happens after something large is resolved, taking inventory of what I felt. A door opened behind me. I turned around. Richard was standing in the hallway. His attorney was a few steps behind him, giving them space. Richard was looking at me with an expression that I did not have a ready category for. Not the expectation of forgiveness, not the self-pity of a man who thinks he is the victim of his own consequences, but something more raw than either of those. Something that looked, if I'm being honest, like grief. He said, "Can I talk to you for a minute?" I looked at Janet. She gave me a slight nod that meant, "This is your call." I said, "A few minutes." His attorney stepped further away. Janet found something to look at in her briefcase. Richard and I stood in the hallway of the county family court, and for the first time in 29 years, we were in the same room and speaking directly. He said, "I know the legal thing is resolved. I know that's not what I want to talk about." I waited. He said, "I want to tell you something, and I need you to know that I know it's not enough. It's too late for it to be enough, and I know that, but I want to say it anyway." He looked at the floor for a moment. Then he looked at me. "I was a coward," he said. "That's the truth of it. I was 26 years old, and I was scared, and I didn't know how to be a father. And instead of learning, I ran. And then I ran far enough that coming back felt impossible. And I told myself that story for long enough that I almost believed it." He paused. "But the child support," he said, "that wasn't fear. I could have paid that. I chose not to. I told myself reasons, but they weren't real reasons. And your mother, what she did, raising you alone without—" He stopped. His jaw was tight. "She's a remarkable woman," he said. "She always was. I was too young and too scared to deserve her, and I proved it." I looked at him for a long time. Then I said, "I know you were scared. I figured that out somewhere around age 25. I also know it doesn't change what my mother went through, or what it was like for me to grow up without you." He nodded. "I'm not interested in punishing you," I said. "The legal process wasn't about punishment. It was about what was owed. There's a difference." He nodded again. "I am open," I said, carefully, "to some kind of contact going forward. A conversation eventually. But I want you to understand something. What I am willing to have with you is not a father-daughter relationship. That was available 30 years ago, and it's not available now. What might be available, if we do this carefully and honestly, is something more like acquaintance. Two people who are connected by biology and history, and who can be honest with each other about what that is and what it isn't." He looked like I had said something that hurt him. I did not apologize for it. "Is that something you can accept?" I said. He said, "Yes. I'll take whatever you're willing to offer." "Then we'll figure it out," I said. I shook his hand. It was the first time I had touched my biological father since I was 9 years old. His hand was large and dry and slightly cold, and the handshake was brief. I walked back to where Janet was waiting. We went to get coffee. We sat in a booth, and she talked about the next steps in the payment enforcement process, and I answered and participated, and somewhere in my chest, the heavy thing was lighter. Not gone. Lighter. "I want to tell you about my mother." I drove to her house on the Sunday after the hearing. I had called ahead, so she was expecting me. She had made food. She always makes food when I come over. It is one of her most consistent expressions of love, and I have learned to accept it as such, rather than protesting that she didn't need to bother. I told her about the hearing, the judgment amount, the judge's words, the hallway conversation with Richard. She listened. She sat across from me at her kitchen table. A different table from the one in my childhood, but somehow with the same quality of light, the same feeling of the place where serious things get said. And she listened to the whole thing without interrupting. When I finished, she was quiet for a moment. Then she said, $206,000. "Yes," I said. She was quiet again. Then she said, "I want you to have it." "Mom, don't argue with me," she said, in the tone that means the argument is over before it begins. "You are the one who has owed it. Not me. I mean, yes, it was for expenses I paid, but you were the one who was owed a father, and instead got what you got. That money is yours." We went back and forth on this, and eventually we arrived at a compromise that I will not detail here, because the financial arrangements between my mother and me are private. But what I want to tell you is what she said near the end of that conversation, when the practical discussion had been completed, and we had moved into the territory of the thing itself. She said, "I want you to know that I kept that folder because I always believed this day would come. I don't know if I believed it consciously. I don't know if I sat there thinking, someday my daughter will be an attorney and she will use these documents. But I kept them. I think I kept them because throwing them away would have felt like giving up on the idea that things could be made right. And I didn't want to give that up. I looked at her. You did this, I said. This started with you keeping that folder. She shrugged, in the way she does when she is moved by something and doesn't want to show it. I did my part, she said. I reached across the table and covered her hand with mine. You did more than your part, I said. You did everything. She patted my hand twice, the way she has done since I was small, and then she stood up and went to get us more coffee, and the conversation moved on to other things. And the Sunday afternoon passed the way Sunday afternoons do when you are with the person you love most in the world, and nothing particularly remarkable is happening, and everything is exactly right, where things are now. The payment schedule is being honored, the lien is in place. The structured withdrawal from Richard's retirement account began on schedule. Janet monitors it. I do not think about it much. Richard and I have exchanged 3 emails since the hearing. They have been brief and careful. He has asked about my work. I have answered. He has told me, unprompted, which I noted, that he told his other children about me, about the situation, about what he did. I do not know what he told them or how they received it. That is not mine to manage. I may meet him for coffee at some point. I may not. I have not decided. I am in no hurry. The pressure to resolve things quickly, the urgency that he brought to the Facebook message, and that the situation seemed to want to impose, is not a pressure I feel anymore. I have my life. It is a good one. He is a peripheral figure in it, and whether the periphery becomes slightly less peripheral, or stays where it is, will depend on things that are not yet determined. My mother is well. She is gardening and FaceTiming her friends, and has recently started a book club, which she reports with the particular satisfaction of someone who has earned the leisure of a book club through decades of not having time for one. I am well. I am doing the work I believe in, and living in a home I am proud of, and I have in the years since I sat in a booth with Janet talking about next steps, arrived at a state that I can only describe as settled. Not without grief. The grief of a missing childhood is permanent, I think. A thing you integrate rather than eliminate. But settled. Present. At peace with the story, even the hard parts of it. I want to end with something I said to a client recently. She was in my office, a woman in her late 30s sitting across my desk, talking about the situation with her ex-husband and the child support order and the enforcement process she was considering. And somewhere in the conversation she said, I just want it to be over. I want it to be resolved, and I want to stop thinking about it. I said, the legal resolution is something I can help you get. The feeling of it being over, that's something you work on separately, and it doesn't happen when the judge signs the order. It happens slowly, over time, as you build the life that proves the story wrong. She looked at me. What story? She said. The story that what he did defined you, I said. It doesn't. It shaped you. There's a difference. It is part of your history, but the rest of the story, what you make of it, how you use it, who you become, that's yours. That part belongs entirely to you. She wrote that down. I thought about it for the rest of the day. I thought about my 9-year-old self at the kitchen table, spelling necessary wrong on a flashcard. I thought about the Wednesday morning and the expression on my mother's face, and the long, ordinary, quietly extraordinary life she built out of what remained. I thought about the folder in the filing cabinet, labeled in careful handwriting. I thought about the hallway in the family court building, and the handshake, and the lightness. The rest of the story is mine. It always was. And it is, in every way that matters, enough. If this story resonated with you, if you grew up with an absent parent, if you know what it is to be owed something you never received, if you have been building your life in the long shadow of someone else's choices, I want you to know that you are not alone. And I want you to know something else. The filing cabinet of your life, the careful record of what you survived, is always available as evidence. It does not expire. It does not have a statute of limitations. What was done to you is documented in who you became, and who you became is the whole answer. Thank you for listening, and if you know someone carrying this particular weight, share this with them. See you next time.